Hello everyone. Welcome back to Nova Real Estate Solutions. Today I'm building on a previous discussion about estate planning by focusing on a crucial distinction: probate versus non-probate assets. Knowing the difference can drastically impact how your estate is handled and how quickly your loved ones can access their inheritance. I've touched on the basic definitions before, but today I'm going to go a bit deeper. I'll explore several real-life scenarios and provide actionable tips to help you effectively manage your assets. Many people believe that having a will avoids probate. Sadly, that's not the case. A will guides the probate process. It does not eliminate it. When someone passes away, their assets are divided into two main categories: probate assets and non-probate assets. So let's explore what each term means and how these assets are treated differently in the process. First, let's talk about probate assets. These are assets that must go through the court-supervised probate process. This is where the executor or administrator ensures that the deceased debts are paid and the remaining assets are distributed according to the will, or state law if no will exists. Some examples of probate assets include solely owned real estate, bank accounts without a beneficiary designation, vehicles that were owned solely by the deceased, personal belongings like art, jewelry, and furniture. For example, suppose John owns a small rental property in his name alone. When he passes away, this property will need to go through probate, which means his heirs won't be able to sell it or rent it until the court finalizes the process or grants special permission. This delay may very well cause his heirs financial strain. Now let's go over some examples of non-probate assets. These assets completely bypass the probate process and go directly to a named beneficiary or co-owner. Some examples include assets held in a trust, jointly owned property with rights of survivorship, life insurance policies with a designated beneficiary, retirement accounts like IRAs or 401ks with a named beneficiary, payable on death or transfer on death accounts. For example, let's say Mary has a 401k with her daughter listed as a beneficiary. After Mary's passing, her daughter will simply provide the necessary documents establishing her identity to the financial institution, and the funds will be transferred quickly. This highlights the efficiency of non-probate assets. But there are nuances to consider. As I mentioned, joint ownership is a common strategy to avoid having real estate probated. But did you know there are different types of joint ownership? Taking title to real estate as joint tenancy with right of survivorship means that when one owner passes away, the other automatically inherits the property. However, taking title as tenancy in common allows each owner to pass their share of the property to whomever they choose in their will. So let's suppose two friends or an unmarried couple buy a home together. One of them dies. Their share of the property might very well go to someone other than the surviving owner. So understanding these differences in title is vital. Also, beneficiary designations are not set in stone. Life changes, so your designations should too. For instance, if you get remarried but forget to update your 401k beneficiary information, your ex-spouse might still be listed and get the 401k money. And if you neglect to name a beneficiary on a retirement account, that account typically becomes a probate asset, which can lead to delays and additional costs. Understanding the probate process is so important. If you're planning your estate, you'll want to minimize probate assets to reduce court involvement, save on fees, and speed up asset distribution to your heirs. This is where a living trust can be a valuable tool. A living trust allows you to transfer assets to your beneficiaries without going through probate. Unlike a will that becomes public record during probate, a trust can remain private. If you own real estate in multiple states, you might face probate in each state. This can be complex and costly, but a trust can help simplify this process. Remember, tools like living trusts, joint ownership, and beneficiary designations are not one size fits all. What works for one person might not work for another. That's why professional guidance is essential. Estate planning is about more than just distributing assets. It's about ensuring that your loved ones are protected and have a smooth transition. Now, we've covered a lot today. If you have specific questions or want to share your experiences, please leave a comment below. I'm here to help you navigate these complex topics. And if you need personalized advice, don't hesitate to reach out to me at Nova Real Estate Solutions. We can connect you with experienced estate planning professionals in the Northern Virginia area. Thank you for watching. Don't forget to like, subscribe, and share this video with anyone who might find it helpful. Until next time, take care.